9th, 2025, Deputy Mendez of the Palm Beach County Sheriff's Office in Florida initiated a traffic stop on a driver named Wiggy for a suspected window tint violation. The interaction that followed was captured on officer body camera footage.
Roll down the back window. 4 words. Recorded on a Palm Beach County Sheriff's Office body camera at approximately 8:47 in the morning on October 9th, 2025. 4 words that within the next 90 seconds would turn a routine traffic stop into a man in handcuffs locked in the back of a patrol car for a piece of plastic film on a piece of glass. Here is the visual you need to hold on to for the rest of this video. A pane of tinted glass. That's it. That's the entire justification chain. Not a weapon, not a threat.
Hello, can you roll down your back window, please? Roll down the back window?
What?
I can't see.
Nobody in there.
Roll down the back window.
Is that a law?
Yes, but I can't see for my safety.
Can't see?
Yes.
Nobody in the car.
All right. You know what? Just step out of the vehicle. Step out of the vehicle, face the car. I'm going to pat you down because you're not
No,
complying with me.
I am not consenting to any search.
Okay, turn around.
I am not consenting to any search.
Start me another unit. Patrol me west. Turn around.
I am not consenting to any search.
Okay, turn
What's your
around.
name and badge number?
I already told you, Mendez 27513. Turn around.
Okay, so you're telling me I
I'm
have
giving
to
you a
turn
law.
around?
Before we go deeper into what the body camera and the case law actually show, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence, statute by statute, all the way to the end. Let's lay out the record. A driver, we'll call him Wiggy as he's identified in the footage, is pulled over by Deputy Mendez of the Palm Beach County Sheriff's Office. The stated reason? A suspected window tint violation. That's it. Not reckless driving, not a broken tail light tied to a stolen vehicle report. A tint violation. The kind of infraction that, under Florida law, gets you a ticket in the mail, not a pair of handcuffs.
Lawful order to turn around.
That's not lawful.
It is. I'm giving
Why?
you a lawful order.
Why? Why is it
Because
lawful?
I'm telling you.
Why is it lawful?
For my safety.
To pat me down?
Yes.
First, you can't see in the back window.
Yes.
And what does the back window have to do with patting me down?
Turn around.
What does the back window have to do with patting me down?
All right, take a seat inside.
So now you want me to go back in the car?
Take a seat.
Okay, I'm gonna follow you.
Yep.
Hey.
Deputy Mendez asks Wiggy to roll down the back window. Wiggy asks if that's the law. Mendez says he can't see. Wiggy tells him there's nobody in the car. And right there, in that exact exchange, you can hear the entire case start to bend. Because Mendez doesn't answer the question. He orders Wiggy out of the vehicle instead. Now, under the Supreme Court's 1977 ruling in Pennsylvania v. Mims, that much is clean. Once a vehicle is lawfully stopped, an officer can order the driver out of the car. No extra suspicion required. So far, Deputy Mendez is inside the lines. But watch what happens in the next 10 seconds, because this is where the line gets crossed.
Turn around.
Why?
Because I just told you, you're going to be detained.
Why did you stop me?
I already explained that to you. Turn
didn't.
around.
Why did you stop
Okay,
me?
I'm going to give you one last chance. Turn around. Put your hand behind your back.
Okay, I'm gonna leave my phone to record this.
Turn around.
Face him like this. You're explaining to the second.
No, it's not an explanation. I'm asking for information.
Yeah, you're gonna get all the You're not gonna walk away with no information at all. You're gonna get everything.
I want to know why I was stopped. I just told you for your windows. Walk this way. For my window.
I'm going to pat you down. That's what Mendez says next. Not, I smelled something. Not, I saw a weapon. Not, dispatch flagged this vehicle. His stated reason is the same reason he gave for the window. He couldn't see into the back seat. The Supreme Court's 1968 ruling in Terry v. Ohio is not ambiguous on this point. An officer may only frisk a detained person when he can point to specific, articulable facts suggesting that person is armed and dangerous. Limited visibility through tinted glass is a reason to be cautious. It is not on its own, a reason to believe the man standing in front of you, hands visible, fully compliant, out of the car, is carrying a weapon. A window is not a weapon. Remember that phrase. You're going to hear it again.
Hey, how far are you? Right there at the intersection, just west of. You're gonna just keep. No. It's going west. I'm going eastbound. There's gonna be a turn lane when you're going westbound. Just stop right there. Because this guy's not complying at all. I'm waiting for you to take him out of the car. All right, so take this turn lane that's right next to me. In case.
Not because of a weapon. Not because of a specific threat. Because I'm telling you. Ask yourself something. If the entire justification for physical control over another human being boils down to 4 words, because I'm telling you, what exactly is restraining that power? Not policy, not statute, just the deputy's own say-so. That's the ticking clock in this story. Not a bomb, not a countdown. A much quieter question. How far does "because I'm telling you" actually reach before the Constitution says it has to stop? Wiggy is handcuffed.
All right, step out of the vehicle. Turn around. Turn around. 4. I'm giving you a lawful order to turn around.
Why?
Because I just told you, you're going to be detained.
Why did you stop me?
I already explained that to you.
You
Turn
didn't.
around.
Why did you stop
Okay,
me?
I'm going to give you one last chance. Turn around. Put your hand behind your back.
Okay, I'm gonna leave my phone to record this.
Statutes generally prohibits tinting on the windshield, except for a transparent strip along the top of the windshield that does not encroach upon the driver's direct forward viewing area. Section 316.2953 requires the tint on side windows adjacent to the driver's seat to allow at least 28% of visible light to pass through, and Section 316.2954 requires the rear side windows and rear window of an SUV to allow at least 6% of visible light through. Driving a vehicle that violates any of these restrictions is a non-criminal traffic infraction, punishable as a non-moving violation. As the United States District Court in the Northern District of Florida explained in the 2016 case of United States versus Longoria, Florida law permits law enforcement officers to stop vehicles that they reasonably...
Wiggy refuses the pat-down. He's not swinging at the deputy. He's not running. He's saying out loud, on camera, "I am not consenting." That's a phrase protected by decades of Fourth Amendment case law. And it's also, in the real world, the exact phrase that tends to escalate an encounter with law enforcement, regardless of whether it should. Backup arrives. And this is where the video stops being about a tint violation and starts being about compliance itself. Turn around. Wiggy asks why. Mendez says, "Because I'm telling you."
that Wiggy's vehicle had sunscreening material on areas of the windshield where no tinting was permitted whatsoever. However, under Section 318.14 of the Florida statutes, most non-criminal traffic violations, including illegal window tint, must be handled by issuing a citation rather than making an arrest. In other words, Florida law generally does not authorize taking a driver into custody solely for a window tint violation. That said, the constitutional analysis is different. In the 2008 case of Virginia versus Moore, the Supreme Court held that an arrest based on probable cause does not violate the Fourth Amendment simply because it violates a state statute limiting arrest authority. Therefore,
placed in the back seat of the cruiser, let's be precise about what Florida law actually says here, because this is where the video separates fact from feeling. Section 316.2952 of the Florida statutes bans tint on the windshield except for a narrow strip at the top. Section 316.2953 requires side windows near the driver to let through at least 28% of light. Section 316.2954 sets the rear window and rear side windows at a minimum of 6%. Driving with tint that violates these numbers is a non-criminal infraction, a paperwork problem, not a criminal one.
Where's your body cam? Is it on?
Right here, you see it?
Is it on, sir?
Let's go.
Are you walking me out inside of the room? To put me
You
in the
wanted
back
to
of my
stop
car?
right here. Yes, sir.
Okay.
Stop right here. Grab this thing. Put it in the front. Take a seat.
Yes, sir.
India Alpha 64 Golf Bravo Silver Vision Lotus Brown.
What's your name? Okay, are you refusing to identify yourself? You're refusing, so I'm going to let you know. If you refuse to identify yourself, I am going to arrest you. Are you going to refuse to identify yourself? Okay, I'm going to ask you one last time.
And under a 2016 federal case out of the Northern District of Florida, United States v. Longoria, officers are allowed to stop a vehicle if they reasonably suspect the tint breaks these rules, even if it later turns out to be legal. So the stop itself? Defensible. But Section 318.14 of the Florida statutes is just as clear on the other side of this. Most non-criminal traffic violations, tint included, are supposed to be handled with a citation. Not an arrest, not handcuffs, a slip of paper. So how does a piece of paper turn into a pair of handcuffs? That's the irony sitting at the center of this entire encounter. The law says, write the ticket.
Of Florida law to subject Wiggy to a full custodial arrest for a mere window tint violation. However, temporarily handcuffing an individual and placing them in the back seat of a police cruiser does not automatically convert a traffic stop into an arrest. The 11th Circuit Court of Appeals, which has jurisdiction over Florida, has long held that it is reasonable for officers to use handcuffs to protect themselves during an investigative detention. As the court explained in the 2004 case of U.S. versus Acosta, officers may take reasonable steps to ensure their safety so long as they possess an articulable and objectively reasonable belief that the suspect is potentially dangerous. And an investigatory stop does not necessarily convert into an arrest because an officer draws his weapon, handcuffs a suspect, orders a suspect to lie face down on the ground, or secures a suspect in the back of a patrol car.
The deputies said, put him in the car. And under the Supreme Court's 2008 ruling in Virginia v. Moore, here's the uncomfortable twist. Even if Florida law says a citation should have been issued instead of an arrest, the Fourth Amendment itself doesn't necessarily care. Probable cause for the underlying violation can be enough to make even an unlawful under state law arrest constitutionally permissible. In other words, Florida's own rulebook may have been broken, and the Constitution might shrug anyway. A window is not a weapon. Second time. Hold on to it, because here's where it gets tested again. Once Wiggy is in the cruiser, a new question opens up. Identification. Are you refusing to identify yourself? Mendez asks.
Simple. I'm gonna, that's it. Step out.
Yes, sir.
Walk this way.
Yes, sir.
Okay. Just hang out here in front of my car.
Okay, Mr. Mendez.
Let me write your tickets and then you can go on your way.
Okay, Mr. Mendez.
While Deputy
Wiggy hesitates, and the deputies invoke a real legal principle. Florida law, under Section 322.15, does require a driver to have a license available and to present it on demand during a lawful stop. The Supreme Court's 1979 ruling in Delaware v. Prowse backs up the idea that officers generally need reasonable suspicion before stopping a vehicle at all. But it does not create a personal veto power, where a driver gets to decide in the moment whether the stop feels legitimate enough to cooperate with. That determination belongs to a judge, later, with the full record in front of them, not to the driver on the shoulder of the road, mid-detention.
Okay. Driving is not a right, driving is a privilege, right? You have to identify yourself when you get stopped. Yeah. It's recorded. You have to identify yourself when you get stopped. You understand that, right?
No. I'm not a lawyer, but I'm very, very versed in my rights. I literally read the book of how to deal with cops, which is why I gave him my name. I was under pressure to either be arrested, which is why I gave my name to you guys. I was literally stopped and told to wind my back windows down because he couldn't see. I said, come take a look. There's nobody in there. He told me to get out the car. I got out the car. He goes, turn around. I said, for what? He's going to frisk me. I said, for what? What does that have to do with my windows? Told me to sit back in the car, which I did. I'm doing everything he did, what he asked. He then calls you, you come up and you guys pull me out the car and put me in cuffs for zero reason. That is a move, that's not even a moving violation, that's a freaking window. I am in no way a threat to any of you guys.
Did you refuse to identify yourself?
That is also under the Constitution that you can, if you feel like you are not being stopped for a reasonable reason, which he never even told me, you can refuse. If he legit say, hey, you were speeding, then he has all right to get it. But he literally didn't even say that. He just he stood behind me for about maybe when I got over that hill. And as soon as I got over that hill, he turned his lights on. I put my turn signal on because obviously I couldn't stop there. And he literally came out blasting. I was ready. And I'm like, what is that for? So I will
Handcuffing someone, or even placing them in the back of a cruiser, does not automatically convert a stop into a full arrest. But objectively reasonable belief that the person may be dangerous is not a rubber stamp. And in this footage, the only stated basis for danger is that Wiggy didn't roll down a window and didn't consent to a frisk. Non-compliance is not the same thing as danger. A man who says, I don't consent, is exercising a right. He is not, by exercising it, becoming a threat. A window is not a weapon. Third time.
Held in the 1979 case of Delaware versus Prowse that officers generally cannot stop a vehicle simply to conduct a license check unless they have at least quote-unquote reasonable suspicion of a traffic violation or criminal offense. However, that rule does not give individuals the right to refuse identification whenever they disagree with a stop or believe that it is quote-unquote unreasonable. Reasonable suspicion is a legal standard under the Fourth Amendment that is determined by a judge using objective facts, not by the citizen's personal belief in the moment, and the Supreme Court has made clear that a traffic stop is constitutionally reasonable when officers have probable cause to believe that a traffic violation occurred. Additionally, during a lawful traffic stop, Section 322.15 of the Florida statutes requires a driver to have their license in their immediate possession and present it upon demand to a police officer.
Because here's the uncomfortable truth about the handcuffs specifically. The 11th Circuit, which governs Florida, has held, in the 2004 case United States v. Acosta, that officers can use handcuffs during an investigative detention when they hold an objectively reasonable belief that the person may be dangerous.
Before I had this tinted, because it was the back in this, I said to them, hey, Florida, can you tint this? I told him I wanted the darkest one. He's like, you cannot put that on there because you're going to get stopped. He's like a legal limit. And he showed me that this thing that looked like shit. Like when he held it up, I was secret. I'm like, that's not even tinted. He's like, that's what we can put on there so you don't get stopped.
Anything. It could be clear. There can be no covering. It makes it lower than the AS1 line. That's as long as you can go.
And this time, it's not just about the frisk. It's about everything that followed from it. The pat-down that had no articulable danger behind it. The handcuffs that followed a frisk that shouldn't have happened. The cruiser seat that followed handcuffs built on a refusal, not a threat. Trace the chain backward, link by link, and every single one connects to that same piece of tinted glass. Eventually, Deputy Mendez writes the citation.
You're going to be getting a citation for your windshield and your rear window's too dark, okay? You got 30 days to take care of it. All right, there's options on here. My name and ID number's here. All right, for your complaint. You're good to go.
Yes, absolutely. And you were out of
Palm Beach County Sheriff's Office.
Alright. I'm gonna clock out of work. I'm gonna give you right now. I'm gonna need your body cam.
You have to request that.
Appreciate it. I would. I will, my friend. Trust me, because that was uncalled for. And like I said, I've had this thing forever. I literally bought my car and put it on there. Never been stopped. I literally have a bunch of cop friends that I hang out with all the time. Nobody said to me about my window. Nobody. You were just
Just fine. I mean, now you know you can't have it. Front or too dark.
Like I said, I'm gonna drive around until actually somebody that didn't want to just pull me out of my car. But you know what? I'll take it off. Just to please Mr. Mendez.
You have to take the front off and get them legal in the front.
This is legal. I literally asked them if this is legal.
Go front to the
Yeah, I guess he's colorblind, maybe? I don't know.
Your whole front is covered.
So now you're assuming I'm
I don't know. Well, you say there's no tint on there. Oh, you even have a camera that's looking through the tint.
trust me. Yes, I do.
Perfect. You have evidence for it.
Hey, look at here. See this line right here? This is the lowest you can have tint in the front windshield. The only way you can cover your complete windshield is you have to have a doctor's note saying you have some kind of medical condition. You send that to Tallahassee. The state reviews it, and they will give you a permit. You have your full front.
And you might be right, Officer.
No, 100%. Evan. So
Wiggy says, in his own words after the fact, that he read the book on how to deal with cops, and you can hear him applying it in real time, citing his rights, refusing consent, questioning the legal basis for every order. Some of what he says is accurate, some of it isn't. And that gap between what he believed and what the law actually allows is the second track running underneath this whole story.
Deputy Mendez and Deputy Wignall get a C+, because although it is unclear whether they crossed any legal boundaries, they escalated a routine window tint investigation into a handcuffed detention.
30 days to fix the tint. Wiggy is released. No further incident. He says on camera that he intends to file a complaint and request the body camera footage. Under Florida's public records framework, that footage, the same footage this video is built on, is generally accessible because it was captured by a government employee performing an official government function, and that makes it public record, not private property. So where does that leave us? Deputy Mendez had lawful grounds to make the stop. The windshield tint alone likely gave him that. But the pivot to a frisk, built on nothing but limited visibility through glass, is a much harder position to defend under Terry v. Ohio. The handcuffs and the cruiser placement sit in a gray zone.
And
Legally
acted in a
defensible
manner that
under
unnecessarily
Acosta
increased
if
the
there was a
likelihood of
genuine safety
escalation during the
concern.
traffic stop. As
Difficult
discussed
to
earlier,
defend if the
Wiggy's main misstep
concern
was treating
really
his
just
personal
irritation at
belief
a
that the
driver
stop
who
was
wouldn't
quote-unquote
comply
unreasonable
fast
as
enough.
a reason
And
to
Wiggy's own
withhold routine
instincts,
cooperation
protect
during
your
a traffic
rights,
stop.
stay
In addition to
calm,
refusing
keep
to
the
roll
camera
down his
rolling,
window,
or
Wiggy
sound.
argued that his window
His
tint was legal
execution,
when the state
treating
law
his
said
personal
otherwise.
belief
He also
that the stop
seemed to
felt unfair as grounds to withhold his name and his license created exactly the kind of standoff that gets people hurt over infractions that were never criminal to begin with. Neither side in this video is the clean hero of the story. Deputy Mendez may have had the right to stop the car and the right to ask Wiggy to step out, but turned a piece of tinted glass into a justification for laying hands on a compliant man. Wiggy may have had every right to withhold consent, but mistook that right for a right to withhold his identity. And that mistake is what dragged a 30-second traffic stop into a 15-minute detention. This is what we mean when we say the system doesn't usually fail with a single dramatic villain. It fails in small increments. A deputy who says, "Because I'm telling you," instead of pointing to an actual fact, and a driver who says, "I don't have to tell you," when the law says otherwise. Two people, both partially right, both partially wrong. And the result is a man in the back of a cruiser over a window. If you want to check this analysis against the primary source yourself, go find the original Palm Beach County Sheriff's Office body-worn camera footage from this stop. Cross-reference it against the plain text of Florida Statutes 316.2952 through 316.2954. And then read the Supreme Court's opinion in Terry v. Ohio in full. Not the summary, the actual opinion. Then come back here and tell us in the comments. At the exact moment Deputy Mendez said, "I'm going to pat you down," did the record in front of you show specific, articulable facts that this driver was armed and dangerous? Or did it show a deputy who couldn't see through a window and decided that not seeing was reason enough? If this breakdown helped you understand exactly where the law protects you and exactly where it doesn't, hit like. Share it with someone who needs to see how a traffic stop actually works. Subscribe to Police Misconduct Case and turn on notifications, because we're back every week with the next case, the next body camera, and the next piece of the record nobody else is reading all the way through.